I have 12 noon, and I'm going to get started here. Good afternoon, everyone that's joining us. I want to say thank you for joining today, our board certification class with tax tips. I am wearing my mask for a reason. I'm encouraging everyone to please wear your mask. Please be safe and stay social distance and get vaccinated. My name is Peggy West. I am the organizer and I'm with Pure Clean, one of the sponsors, and I'll say a little bit about the company and then I'll introduce the others sponsors that we have today. I just want to start off by saying that tomorrow's relationships start with today. So I hope that you get some great information today from Scott and also from Nicole and Bill, as well as your sponsors, and enjoy the afternoon here with us. Pure Clean has been in business for 30 years. We are corporate based out of Tamarack, Florida. And I particularly work for the franchise that is Palm Beach County going north to Martin County. We have approximately 30 different franchise locations throughout the state, and we are the service experts for remediation of water damage, fire, mold. We also do biohazard treatments and COVID-19 treatments. With that, I'm going to go on and start introducing the rest of the sponsors. I'm going to start with my co-organizer and the moderator for today, Jonathan Duro from Vinteum. Jonathan, you want to say a few words about Vinteum, please?
I'd love to. Thanks for the intro, Peggy, and thank you everybody for attending. I work with Vinteum Software. We make websites, public-facing websites and secure back-end communication portals. We've been in business since 2014. And as a new board member, you'll find that communication is one of the most important aspects of your role, right? Keeping everybody informed from the property manager to fellow board members, committee members, residents, tenants, that sort of thing. And we make that job easier. So that we have announcements with SMS, email, push notifications, we've got automated voice calls, we could track all of your documents, which is really big. If your community is over 150 units, there's some legislation that requires you to be transparent with regards to documents. And we kind of help with all of that. We also help you facilitate board meetings through Zoom. We could help you with the notice aspects that you're going to hear about today in our meeting and a lot of other tools, as well as tracking pets and vehicles and all the residents information, parking information, emergency contact, all that fun stuff. So if you need any help with that, feel free to reach out. Thanks.
Thank you so much, Jonathan. Excellent company for all those who are listening today. Next, I want to introduce Beth Rappaport with Brightview Landscaping, longtime professional in the industry. What do you have to say today?
Thank you, Peggy. Thank you for having me. And good afternoon, everybody. I'm really excited to be here. I'm Beth with Brightview. And thank you to our speakers and our sponsors, as well as our attendees. It's nice to see everybody today. Our teams create and maintain beautiful, safe outdoor environments for communities just like yours. We do landscaping, fertilization, pest control, irrigation, mulch, tree care, and sports and specialty turf. So please feel free to reach out to me. I'm always happy to provide a no-stress quotation for any size project. Thank you.
Okay, Beth, thank you very much. Good company. My next sponsor that I want to introduce before I announce the speakers is a representative from Hotwire Communications. This is Fifi Madre. You want to tell us a little bit about Hotwire, please?
Yes, thank you so much, Peggy. Good afternoon, everyone. My name is Fifi Madre, Senior Business Development Executive at Hotwire. I've been with Hotwire for almost 11 years now, and we're very honored to have the opportunity to speak today. I know some of you may know of Hotwire, may not. Just to briefly tell you about Hotwire, we're the largest privately held cable franchise operator in Florida. It's a family-owned business by Michael and Kristen Karp, started out in Philadelphia back in 2000. And we've been operating in Florida since 2005. We own and operate our own fiber optic network. And we pretty much serve from Florida all the way up to New York City, with Florida being our largest market because Florida has the largest concentration of condos and HOA. Pretty much what our company does, what sets us apart is that we provide 95% of our business. We provide bulk services to condos and HOA over our fiber optic network. So basically, we come in and build a brand new fiber optic infrastructure and bring fiber all the way into your unit. Not only do we upgrade your telecommunication infrastructure to a state-of-the-art fiber optic, but when we come in, we upgrade your in-unit wiring from coax to Ethernet. We also have our call centers. We have one in Atlanta, one in Pennsylvania, and one in right here in Fort Lauderdale. We operate 24/7, 365, and we do not outsource any of our call center agents. So if you know of any association that their bulk contract is coming up for expiration, I would love to have a more in-depth conversation about how Hotwire can future-proof your home with our state-of-the-art fiber optic technology, and while giving you the best customer service experience. Thanks for taking the time to listen to me, and I look forward to speaking with you all again.
Okay, great, awesome. Thank you so much. Now, I just want to remind everybody that if you have a question, put it into the chat box. Jonathan is our moderator, and he is going to call these out intermittently between the presentations. So let me first introduce Scott Wortman. He's with SJW Law Group, and he has his dynamic dual team here with Nicole and William, or Bill, we call him, Kilgallen, and they're with Hafer Company. So I'm gonna let you take it, Scott, introduce yourself and pass it back and forth, and enjoy.
Thanks, Peggy, and thanks everyone for joining today, and thanks to Jonathan, Peggy, for setting this up today. I really enjoy these board certification courses. It gives me the chance to share with board members, particularly new board members, my knowledge and expertise as relates to the goings-on of being a board member for a homeowners association or a condominium association. Again, my name is Scott Wortman. My law firm is SJW Law Group, PLLC. We're located in Wellington. We represent approximately 70 communities throughout South Florida, handling all aspects of the legal affairs of an association, from collections to governance related issues, to reviewing contracts, to attending board of directors meetings, as well as doing courses just like this. I've been practicing law for approximately 27 years, and I'm Florida Bar Board certified in the area of condominium and plan unit development law, as well as Florida Bar Board certified in real estate law. There's approximately 30 attorneys in the state of Florida with those two certifications. So again, it's my pleasure to be here. I look forward to hearing your questions as we go. And I thank Nicole and Bill, who will add quite a bit to today's discussion, and I'll turn it over to them.
Thank you, Scott. We appreciate everybody's time today. And just so you know, we've been together the whole time through COVID, so we don't social distance because we've been together, but my office does. So I wanted to make that known because there's two of us here, but my office is still working from home. So I appreciate everybody today coming. It's a great class. Scott does an excellent class to really educate a lot of you new board members and understanding what you need to do because you're running a business. Our firm is a full service CPA firm. We concentrate in the area of HOAs, condominiums, developer turnovers, taxes, and we do a lot of consulting work. A lot of our associations will call us for tax information, for audit, budgets, educating them on the budget, especially last year through COVID, what they needed to do, what they should be incorporating into their budget, and then also the reserves. There's a lot of confusion to board members regarding pooling reserves, component method, what they can and can't do with 718 versus 720. So today we're hoping we're going to be able to answer a lot of those questions that you have as new board members. I'll turn it over to Bill, my tax principal.
Hi, everyone. Good afternoon. We at Hafer here also do, as Nicole said, some tax and consulting as well. And in the tax arena, probably pretty recently, we've done a number of buildings that have gotten antennas on it. We've done some sale of common property, and we've had some consultation with respect to some cable services. And so on the tax side, we've seen that there's a lot of questions regarding the taxability of some of these revenue that you're receiving from outside and how you can mitigate that. On the consulting side, we've also looked at a number of clients that have done some mergers, as well as people that are leaving the business because they're retiring and they're selling their businesses and want to know how to officially set up a tax structure for that. So enjoy the presentation this afternoon. Okay.
I'll
Scott?
turn it back to you, Scott.
Okay. All right. So there's a whole bunch to cover in a relatively short period of time. The 2 hours or so will go by rapidly. So I'm going to try and hit, what I feel and what Nicole and Bill believe are to be some of the key important points of being on a board of directors for a condominium association or homeowners association. And just so you know, there are nuances and differences in the law and procedure as it relates to condominium associations and homeowners associations. I'll do my best to articulate the differences as we hit some of these topics, but just be mindful that, depending upon whether you're with an HOA or a condominium association, the answers could be slightly different. On top of the fact that the answer could always be different depending upon the unique nature of the language and the governing documents of your particular association. So answers to certain questions may be, and oftentimes are subject to the precise language in your community's governing documents. But there's a fair number of basic principles that we could hit today that I think will be very useful. And I'm going to start with the first topic, which is how to run a board of directors meeting, because that's something that you as a board member will be dealing with quite a bit, hopefully on a routine basis. Although I have seen some associations that shy away from conducting board of directors meetings regularly, which is problematic. But presuming that you do conduct regular board of directors meetings and participate in those, here are some important points. This may seem axiomatic, but I'm going to say it anyway. The president of your board of directors is in charge of that board of directors meeting. Sometimes these meetings become a bit of a free-for-all, where members speak over each other and there's not an orderly way in which business is being conducted. If you are the president of your community, of the board of directors, you are the captain of that ship for purposes of that meeting. You steer the meeting, you follow the agenda, you call for votes as appropriate. So the president has a special role unique to associations, in particular as it relates to the conducting and overseeing of a board of directors meeting. That's really the extent of the president's role, in fact. There's perhaps a misconception that the president kind of does whatever the president feels like doing and takes on authority beyond just this role at a board of directors meeting. The president has one vote, just like every other member of a board of directors. The president does not have any special authority to do anything other than run the board of directors meeting. Now, a president, just like another member of board of directors, could theoretically bind an association by signing a contract. However, when contracts are signed by an association, it usually is never a good idea for just a single board member to execute a contract. It oftentimes should be at least two board members, and it should be done subsequent to a board of directors meeting taking place where there is a vote to approve a certain contract. To keep whether it's the president or any other member of the board of directors from acting unilaterally on behalf of the association. The vice president's role is pretty simple, self-explanatory. If the president is absent from a meeting, the vice president steps into the shoes of the president and runs and controls the board of directors meeting. That's the extent of the vice president's role as far as being an officer. When it comes to a board of directors meeting, a board of directors meeting is to be conducted only when there is a quorum of the board. Quorum is a special legal term, which a lot of you probably are familiar with, but I'll state it anyway. It's a majority of the members of the board of directors. So if you have a 5-person board, if 3 folks are present in the board of directors meeting, you have your quorum and you can conduct your board of directors meeting. Be very careful though, when you have a quorum and you can conduct a meeting, when a majority of the board is getting together and association business is being discussed, even if it's not in a formal setting, even if it hasn't been noticed, even if it doesn't look like a traditional board of directors meeting, It is a board of directors meeting when a majority of the members are of the board of directors are present. And here's the key: an association business is being discussed, then you have an obligation as a board to notice that to the community for purposes of ensuring that the membership has the right to witness your deliberations and vote as it relates to certain issues. Common mistake of boards are behind the scenes, secretive get-togethers where they make decisions as it relates to important association related matters without having noticed that get-together to the community. That is improper and potentially subject to legal action. So be very mindful of that. A common term that I've seen thrown out is the idea that boards can do closed door meetings in something called executive sessions. There's really no such thing as an executive session. There's no such thing as a working executive session or working meeting where the board gets together and does invite the membership to discuss different association business. That's not permissible. There are two exceptions. The two exceptions as it relates to closing a board of directors meeting involve when there is pending or threatened litigation and the association's attorney is present, because those communications between the board and the boards and the association's counsel are attorney-client privilege communications that the membership should not witness or be privy to or hear in any capacity. So that is an example of a properly closed board of directors meeting. That does not mean that the meeting should not be noticed, though. The meeting should still be noticed, and on the notice itself, it should reflect the fact that legal issues are being discussed with the association's counsel. And pending or threatened, those words have meaning. Pending obviously means existing litigation, an existing lawsuit that's been filed in court and is going on right now. Threatened, if there is a letter or an email sent, say by a homeowner or some other third party, threatening to file a lawsuit or bring some type of claim or file an arbitration case in the division of condominium against the association, that constitutes a threatened action, which gives rise to the board having the right to have a closed meeting, again, with the attorney present. Now, the attorney doesn't have to physically be present. If the attorney's on a call on the telephone line, that's permissible. If they're on the Zoom call, same thing. That constitutes the attorney's presence. So that's category one of the exception to the membership being present at board of directors meetings. Category two, exception number two, is when the board is discussing sensitive personnel employee related matters. Say, for instance, the board is considering letting the property management company go or hiring a new maintenance person. Those are personnel type decisions which need not be done in the open, need not be done in front of the membership, and can be part of a closed meeting, again, still subject to the notice requirements. So be very mindful of those, because oftentimes boards of directors run afoul of these notice requirements. And what's the policy behind all this? It's good to understand the reasoning why these rules exist, and these rules generally derive from, as Nicole had mentioned, Florida's Homeowners Association Act, which is Chapter 720, that governs homeowners associations, or Florida's Condominium Act, Chapter 718, which governs condominium associations. Probably not too many folks on the call today are part of a timeshare, but timeshares also have their own set of laws and rules, which are very, very similar to Florida's Condominium Act, and that's governed, the Timeshare Act is governed by Chapter 719. So the policy behind this notice requirement is that the membership is supposed to see your deliberative process. They're supposed to be able to witness the back and forth, which sometimes is uncomfortable for members of boards of directors, for people to be able to hear the give and take, the debate among, and sometimes fighting, if you will, among the board of directors. But that is part of the process, just like governmental agencies are regulated by the Open Sunshine Act. The Open Sunshine Act meaning you have to shine the light on the agency actions so the public could witness the deliberations and see how how decisions are made. The same concept holds true for homeowner associations and condominium associations. As far as the running of the meeting itself, generally speaking, most association bylaws follow parliamentary procedures called Robert's Rules of Order, which is a fancy old English set of parliamentary rules that simply lay out, well, how do things get done in the context of a board of directors meeting? The way it should be done, not always, but it is important that these be followed so it's properly reflected in meeting minutes. Meeting minutes are critical because meeting minutes reflect the actions of the board. If a member, an owner, seeks to challenge a particular decision, whether a decision was actually made to begin with, the proof that that action was taken, that a vote was taken, that a motion was made, appears in meeting minutes. So it is important, sometimes overlooked, that accurate meeting minutes occur and be taken down during the course of a board of directors meeting. Now, it doesn't have to be a verbatim transcript, nor should it be. That's overkill. But summarizing the highlights of a meeting, particularly that a motion was made by so-and-so for as it relates to the following action. And then a second of that motion is supposed to occur by a board of director. And then from there, many associations skip the next process. The board is supposed to deliberate as it relates to the pending motion. And this is almost always skipped. The membership, if there are members present at the board of directors meeting, they should have the right to say what they feel like saying about the particular motion, give their opinion for no greater than 3 minutes. And once that process has been exhausted with all the members that wish to speak on the particular motion that's on the table, then the motion is voted upon by the board of directors, and that vote should be reflected in the meeting minutes. During the board of directors meeting, as a board member, it's important you get your business done, that you run through the agenda smoothly and easily. Easier said than done, for sure. And oftentimes what occurs is the membership feels as if should be a give and take session, a question and answer session, where they want to interject their opinion right away as it relates to an issue, raise their hand and ask questions. While most boards of directors will be happy to indulge the members when they're polite enough and they have a question, they'll field the question. Technically, just so you guys know, as members of a board, this is not a question and answer session period. You're not there to be on the spot to get interrogated or for questions to be thrown at you by the membership. You are not obligated to answer the questions as posed by a member. You have the right to, you won't run afoul of any law, but particularly in cases where a meeting could get a bit prickly and ornery, you have the absolute right to shut that down and say, we are not taking any questions. At the conclusion of what the board is seeking to do from a business standpoint in the agenda, the board has the ability to then open up the floor for a member to speak for no greater than 3 minutes on any issue that they feel is important, but it is supposed to be a one-way street where they say what they feel like saying, and once the 3 minutes is up, or if they finish sooner, that's fine, move on to the next person. If the board feels like answering a question, they have the right to do that, but again, as a board member, you have no obligation to do so. Videotaping and audio taping. Sometimes you'll see members walk into a meeting with a tape recorder or perhaps even a video camera. Both Florida's Condominium Act and Florida's Homeowners Association Act allow for this, believe it or not. However, the statutes both say the same thing, that the board can promulgate rules and regulations pertaining to videotaping and audio taping board meetings. So a good idea for the board to do, among other procedural items, is to adopt rules related to audio taping and videotaping. For example, that the member has to notify the board at least 24 hours in advance of their intention to videotape or audio tape, that there cannot be lighting or sounds emanating from the equipment that is distracting to the board of directors. And if so, those devices can be removed. Another similar type administrative components to videotaping and audio taping.
Scott, I have a question for you.
Sure.
So we had an association, because everything's been by Zoom, and in the past, they had never videotaped their meetings. Well, when they started the Zoom, they started videotaping it. The unit owner got upset because they weren't making it known to everybody that they were videotaping it now through Zoom. Do you have to make it known to everybody that you are?
No, there's no statutory requirement to do that. However, might not be a bad idea. So obviously, if you as a member are saying something or doing something on a Zoom meeting, it's basically open to the public. So this is not a private setting in that respect. And so the members should be forewarned and understand that what they say and do could potentially be recorded, both video and audio. But it's probably good practice for the association at the outset of the meeting to advise the members that the meeting is being recorded.
Thanks, Scott.
Generally speaking, board of directors meetings are to be done on 48 hours notice. That's true for homeowner associations and condominium associations. That's the traditional board of directors meetings. There are a whole slew of exceptions though. First, emergency meetings, as we've all dealt with COVID over the past year or so, there have been situations where it was important for the board to get together immediately, particularly the beginning stages of the pandemic in March and in April, where I was asked several times whether or not the association needs to comply with the 48-hour notice, because we have to immediately address, say, for example, the closing down of the pool in order to comply with CDC guidelines. In a situation like that, I'm of the opinion that the 48-hour notice need not be complied with, and an emergency meeting done within a day or a few hours can be held for that single purpose. However, today, we're past those emergency declarations and emergency type actions. So I would definitely err on the side of properly noticing a meeting on 48 hours notice, a traditional board of directors meeting. There are other time periods that also come into play. The 14-day notice pertains to budget meetings. And so all budget meetings have to be done on 14 days notice, where the budget is submitted along with the notice in advance to the membership. Meetings that involve adoption of amendments also require 14-day notice in advance, where the notice is sent out along with a copy of the proposed amendment. Elections obviously carry a very different notice schedule. Condominium associations are quite different than homeowner associations, although you'll see many homeowner associations adopt the condo association election notice procedure. And so here is the condo association election notice requirement obligations per the statute. The first notice has to go out at least 60 days in advance of the annual meeting and election. 40 days from the annual meeting and election, the individual who seeks to be a candidate for the board must submit their intent to be a candidate, and you solicit these folks to submit their resume and identify themselves as a candidate in that first notice, in that 60-day notice. The next time period, which is a 35-day notice 35 days prior to the annual meeting and election, the candidate is to submit their resume to the board of directors, which could be sent out to the membership. And then the second notice of annual meeting is sent out 14 days prior to the annual meeting and election. Homeowner associations are very different. There is no specific timeline in terms of the 60, 40, 35, 14. It is 14 days unless otherwise stated in your governing documents. So for homeowner associations, for members of the boards for your HOA, we have to look at the bylaws to see what the notice obligation is. And if there's a desire to use the 60, 40, 35, 14-day scheme like condominium associations, you can do that, but it would be important to either adopt a resolution to that effect at a board of directors meeting, or potentially might be necessary to amend your bylaws through a formal amendment process. One or two more topics, then I'm going to turn this over to Nicole and Bill. If there's a vacancy on your board, happens time to time, or a member of the board of directors said, I've had enough of this, I'm done. Or I've decided to move to somewhere else and I can no longer serve on the board. If there's a vacancy on the board, it comes down to, again, I sound a little broken record-ish, how your governing documents read, in the sense that if your bylaws state that vacancies may be filled by the board, as opposed to shall be filled by the board, and sometimes these things turn on one word, literally one word in your governing documents. It says may be filled by the board, then the board of directors has the option to fill that vacancy with whoever they desire based upon a vote of that board of directors. Sometimes it's unanimous, sometimes it's not, but that'll be up to the board of directors exclusively. If someone resigned, it doesn't mean you go right to an election to fill that vacancy. If it is a shall in your governing documents, then the board is supposed to convene as soon as reasonably possible for the purposes of appointing someone, and do that swiftly, because shall is a mandatory term. Being on a board of directors carries a lot of responsibility. You have a fiduciary obligation to the association. What does that mean? It means you're supposed to make decisions which are in the best interests of the association. Doesn't mean every decision is going to be perfectly on and correct and work out exactly as planned. Of course not. Luckily for board members, there is something called the business judgment rule. That is a concept in the state of Florida, which provides you as a board member are not to be held liable, will not be personally responsible if one of your decisions turns out to not work out so well for the association. Actually, the association lost money as a result. You know, a negligent decision does not give rise to liability on your part as a member of the board of directors. You are insulated from such liability under this concept called the business judgment rule. Again, like everything, there is an exception or two. If you act with malice as relates to a particular homeowner, or there's intentional wrongdoing, if you embezzle money or commit fraud or engage in conflicts of interest where you give your brother-in-law the landscaping contract, that will be an exception to the business judgment rule, and you could face liability. But those are very rare cases, and hopefully will never occur with any of our 19 participants on the call. Another backstop to liability is Dno coverage. Your association rightly should have directors and officers insurance coverage in place, which if you were to be sued, because anyone could sue anyone for any reason, wherever, that doesn't mean you'll be faced with liability. First of all, you'll be insulated under a business judgment rule, but counsel will need to be hired to mount this defense. And almost always your directors and officers insurance coverage policy will be triggered, and the insurance company would hire an attorney for you to defend your interests in such a case. Okay, I think I rambled on quite a bit as it relates to the first couple.
Scott, can I ask a quick question? What happens if the association doesn't have the Dno insurance? Does that make change any requirements in terms of how the board acts?
No, the board members should still feel settled in the idea that they're protected under the business judgment rule. Plus, many sets of governing documents actually include an indemnification provision for members of boards of directors, where if a member was sued in such an instance and there was no Dno coverage that was triggered, an insurance attorney assigned, the association, through an indemnification provision typically seen in association's governing documents, would then become responsible for potentially hiring an attorney on behalf of that board member and covering any possible judgment that would be entered against that board member. Again, as long as they didn't act maliciously or in a way that violated or broke any criminal law. Did that answer your question, Bill?
Yes, thank you.
Okay, good. So talked a lot about the goings on and the machinations of being on the board, the financial aspect, which is connected to what I was just talking about in terms of fiduciary obligations, pertains directly to annual audit obligations, because that is a big annual activity of both Florida condominium associations and homeowner associations. That's where Nicole and Bill could take over as to that issue.
Okay, thanks so much. We'll try to make this interesting. I know the financial aspect is not always the most interesting to the board members. So it's actually a crucial part of your business. You are running some of you are running multi-million-dollar businesses. You know, you have maintenance fees that are $3-4 million. It's not just a nonprofit. So you want to make sure you know that. We'll talk about that on the tax side in a little bit. So under statute, this pertains to Florida Statute 718, condominiums, 719, if any of you are cooperatives, and 720 homeowners associations. All the annual reporting is the same under all three statutes. So the first is all based on your income level. So the first starts with, if your income is 150,000 to 300,000, you're actually required to do a compiled financial statement. Now in the statute, it does not say that the compiled financial statement has to be done by a CPA firm. It was a lot of controversy back and forth when people were saying, well, we get a financial statement from our management companies that are accrual-based accounting. It doesn't say that it has to be done by a CPA firm, but you want to make sure that those compilations that you're getting are true compilations, that they're including, you know, the footnotes and all the information that's required under the statutes for a compiled financial statement. If your income is 300,000 to 500,000, it's actually required a reviewed financial statement. And then 500,000 or more is required an audit. Now, if your document states something different, you definitely want to talk to your attorney for advice, because we've gotten some things where they say, some attorneys have said that if it's in your document, you're required to have it. Some are saying, well, what was the intent of it? So always consult with your attorneys on if something in your documents conflicts with the statutes. I'm just talking about what the statutes require. An audit is actually where we're going in and we're actually attesting to all of those numbers. So a CPA firm is going in, they're looking at those numbers, they're actually testing invoices, minutes, documents, loan documents, and they're actually reviewing all of it, and they're giving an opinion on those financial statements. It's the highest level of assurance on a financial statement. I know that if I was a board member on an association and I was running $1 million or a $1.5 million budget, I would want an audit just for the security to the homeowners that everything is being looked at, the financial statements are materially not misstated, and making sure it's being done correctly. A reviewed financial statement is basically analytical procedures. We're not attesting to anything, but we're going in and we're doing analytical procedures on the budget. We're looking at things to make sure that they're properly posted, and if there's any adjusting entries, we are proposing them. On a compiled financial statement, there's really nothing being done. And I'm just being as honest as possible to everybody out there. We're basically taking your financial statements, we're putting them on our letterhead, we're reviewing to make sure the numbers are correct. We're not doing any attest work. So that's why some associations choose to use the management company. Some ask us to do the compilation because they're saying, we can consult with you if something you see unusual. Absolutely, we'll consult with you. We'll say this should be changed differently, but we're not doing anything on the internal controls regarding a compiled financial statement. Now, if you're required to do an audited financial statement, if you want to do a lower level of service, let's say you say, well, we've had an audit done and we want to do a review this year. It would require a membership vote to lower the level of service. So if you wanted to do a review, you would have to get together and put a membership vote in order to do a lower level of service. So you would have to vote to not do the audit and do a review, or vote down to do a compilation. If you're required to do a compiled financial statement, the board can elect to do a higher level of service. It is not required by the membership. I've had some boards where they've had some special assessments and they've decided that let's do an audit because there was so much money running through that association. They stepped it up to an audit, which doesn't require a membership vote in that. And it's very important to know that because it has to be done before year end. I've had some boards where they say, you know, we'll do it at the annual meeting the next year, but it's required to be done before year end. So make sure that you're looking at that and saying, what is our requirement, and it's all income. I've had some associations come to me and say, our maintenance fees, excluding the reserves, is under 500,000. Well, reserves is income. So it's going to be your entire budgeted amount. And one of the controversies going on right now out there is there's a new ruling called a new accounting standard called Topic 606. And what it's done in layman's terms is in the past, you would show reserves on your income statement in the audit. If you didn't spend it, it would roll to your fund balance and just sit on the income statement and fund balance. That has changed now. And now reserves are actually sitting on the balance sheet as something called a contract liability. And as you spend it, it gets recognized as income. So what the controversy is, your budget, let's say, shows $750,000, but on the audit, your income is only showing $450 because the reserves now are on the balance sheet. So one of the topics we brought up to DPBR is, what is your determination? The audit report or the budget, what they're required to have, because they're not going to equal anymore. And we've gotten back and said, the DPBR said, we haven't had anybody turn it in yet. So we don't have any guidance for you. So what we've told our associations is I probably just rely on the budget because that number is showing the total amount that's being collected, even though the audit is different due to the new revenue recognition. And until I guess somebody's turned in and they make a point of what they're going to determine, what I think needs to happen is the statute needs to change to determine what is income based on the audited financial statements or based on the budget of what they're collecting. And I think down the road, that's going to have to be changed. I sit on the FICPA, Florida Institute of Certified Public Accountants, for this industry, the CERA industry. And we brought it up that we're going to have to put something or try to put something through legislation in order to change that, because people are going to be very confused on that aspect.
I think the biggest question that they have is, how come my financial statements don't look like my budget does, and the reserves I would expect to be more on the financial statements than what I see, because it's now gone into that contractual liability. So conceptually, it's hard for a layperson who's seen the presentation so many years like that to now go into this new FASB requirement, if you will, Financial Accounting Standards Board, to change the way that presentation is. And it's really an anomaly because of the fact that the FASB board has moved always going forward all these years to make the financial statements more transparent for a reader that's a non-accountant or non-layman in the accounting field to be able to read and understand it. And so this presentation and this 606 topic that's been implemented now is causing a lot of conversation out in the financial field.
And please don't hesitate if you're a board member or you're a manager to reach out to your CPA firm when they're done and get educated on it. Have a closing meeting, because they're so different than they used to be that even CPAs that sit on the boards of these associations are confused on the new standard. So please reach out to whoever's doing it and reach out to them and get an education on it so you can understand in the future. So,
thanks, Nicole. Bill, I've got a couple questions that are coming in. I've got one. So our HOA is a nonprofit organization. What does this mean when it comes to like a cafe that's being run for the HOA at a profit? How does that impact some of those financial statements?
Yes, what happens is when you're a nonprofit, any activities that you've got outside of the actual operations of the nonprofit is subject to tax. So in that particular case with the cafe, the income coming into the cafe along with the related expenses, direct and indirect, then bring you to a taxable position, and you would in effect pay tax on whatever profits you have from a cafe. Typically what we see though in clubs and nonprofits is where they run these operations, they're usually at best break even or end up losing money, but there's still a presentation on the tax return to show that revenue and that expense it's required.
Can you make it clear to them what the difference between a nonprofit and a not-for-profit is?
Sure. So a lot of people that we get questions from say, well, my association is a nonprofit and, you know, we don't pay tax. Well, that's not really the case. In Florida, there's when you form a corporation, you have an opportunity to check either a not-for-profit or a profit corporation. The distinction in Florida law is that a not-for-profit is only a company that doesn't intend to draw a profit, nor does it intend to pay a dividend out to its shareholders. Whereas a true not-for-profit tax exempt is an association that's gone out and made application with the IRS to become a tax exempt organization under 501c3, which is a charitable organization. So, you know, it's really a misnomer sometimes with the way that it's set up in Florida that, hey, I'm a not-for-profit, I shouldn't be paying tax. That's not the case.
Correct. And there was one more question on there. It said, can a nonprofit HOA charge residents for a non-HOA services such as close and open windows, storm shutters, using maintenance staff after work hours or on work time to staff, and a leftover contribution to the operating reserves?
Yes, you know, we do see a lot of condominiums where they do provide services to the homeowners in terms of repair and fixing items within their particular unit. And so that income that comes in from that, whether or not there's a profit element or not, does get reported on the tax return once again with the associated income and the expenses and such. If it turns out that there is a little bit of a profit, then the association will pay tax on it, depending on whether they're filing an 1120H. The tax would be at 30%. If they're filing as a normal association under 277, they'd file not only a federal tax return and pay tax at 21%, but they'd also have to file a Florida return and pay tax at 4.5% on that.
And last year in 2019, Bill, were you seeing a lot more associations paying tax due to the interest rates? And what are you seeing this year in 2020 with HOAs and their tax position?
This year, I think that a lot of the associations are getting more astute in terms of this income that they're bringing in. Last year, especially so with the market as good as it was, there was a lot of associations that were sitting on increased reserves and taking those monies and going out and either investing them or putting them into CDs. And so that interest income, whether it's from their operating account or from their reserve account, is subject to tax. And because that those earnings are more of a situation where they're, you know, just earned, there's no activity associated with that income, it was very hard to ascribe expenses against that to bring it down, and they ended up paying tax on that. And so now the associations have looked at some different ways in which they could mitigate what that tax might be going forward.
Bill and Nicole, let me ask a quick question as relates to this topic. What about in a situation where an association has foreclosed on a home and is renting it out and deriving rental income? Sounds like that would probably be a taxable event. However, what if that particular unit owner account that they foreclosed on has a large deficiency, an unpaid balance? Is it possible to apply that rent to that unpaid balance to avoid a tax liability?
Yes, that's a great question, Scott, and that's asked of us very often. What typically happens is we build up a basis for them to compare against that revenue that they're going to receive or proceeds from the subsequent sale of that unit by looking at the AR that they've set up an allowance for, okay, as well as any property taxes, because as you know, each of the units, whether it's a home or a condominium, are billed for their real property taxes every year. To the extent that the associations paid those taxes throughout the foreclosure period, that would go to add basis as well and reduce any potential gain that the association would have on the sale. And as a further note, we've also just very recently looked at some situations where we had a unit that was turned over and became part of the common area. And now they're deciding to subsequently sell it. So the question is, how do you mitigate a sale of that particular unit, which has no basis, because a lot of the common area has no basis when it's turned over from the developer? How do you mitigate or eliminate that gain that you might pay on that? We've got some answers that, depending on what the fact pattern is, to address that.
Right.
Terrific.
So the next, go ahead. The next thing we'll talk a little bit about is budgets. So I think that last year, I think we were extremely busy and a lot of consulting with associations on their budgets through the COVID process. And it's interesting because when COVID hit, prior to COVID, we had always advised our associations about building into their budgets and into their fund balance 2 to 3 months worth of operating. To always think that your fund balance is financially secure, building into your budget's contingencies. And many associations did not do that. And when COVID hit, they were basically on a very tight budget to be able to start sanitizing things, the increase in possible payroll, increase in supplies. So one of the things we always bring up when you're doing your budget, the first thing is it's an estimate. It is not an actual. You're going to be looking at things, and yes, you're going to be looking at last year. You're going to anticipate what you expect in the coming year. And you're going to have contracts that, yes, you can put those dollar amounts in, but there's certain areas that they're just estimates. And there's going to be things that come up in the year that are not foreseen in your general repairs and maintenance. If you're not maintaining the building properly every year, there's going to be much more in those repairs and maintenance. If you're not funding reserves, fully funding the reserves, there's going to be things that are going to obviously come up that you're going to have unexpected that you're going to have to build into that budget. So when I talk about the budget, you're going to look at estimates. You're going to go line by line and look at the prior year, and you're going to say, do we think that we're going to anticipate more things happening? Are we an older building? Are there things that are going wrong every year, like our plumbing, concrete restoration? Do we have concrete restoration in our reserves, which many associations do not fund for? That's one of the areas that I see a deficiency is they're not putting aside for concrete restoration. They use painting, paving, and roofing, and they always exclude that. And they say, well, it's such an expensive amount that when it comes due, we'll special assess. But if you really projected and looked at that and said, let's do it over the 30 year or 40 years of that concrete restoration, maybe you would save in those large special assessments. So in doing that budget, it's very difficult for a board, and you should really be sitting down with your manager and really looking at those and say, okay, what are the line items we should be increasing? And then the area that I see a lot of deficiencies in is the reserves. And what I mean by that is understanding the calculations, understanding pooling versus component method, understanding, are you 718 condo or are you 720 HOA? So let's start with the reserve portion. First thing is the pooling method versus the component method. The pooling method is, we find it much more flexible for the board members. I like the pooling method if you have a very financially solvent community and also a fiscally responsible board. Because people will say, well, the pooling method, if we get a board on that likes to spend money, they could go and redo the carpets that were done a year ago. And you're absolutely right, because they can use it for any of those line items. However, what makes the flexibility is any reserve line item that you have set aside can be used with any of that money. So if you have $1 million in the pot and you have 20 line items in your reserves, any of that money can be used for any of those line items. So it gives you more flexibility, especially in emergency situations. If you anticipated the roof was going to cost $500,000 and it comes in at $750,000 and you have the $500,000, if you're in the pooling method, you can use the $750,000. If you're in the component method of reserves, every line item is separate, and only the money you have funded in that line item can be used for that expense. If you want to use money from another line item for another line item, it does require a membership vote. Unless the state is in a state of an emergency, the governor declares a state of emergency, it's a different situation. You could use it for another line item. However, it does need to be paid back. So you are in a sticky situation with that. But I would say 95% of our associations that we do are in the pooling method.
Or moving to it.
Or moving to it. So there's two ways to do that. Let's say you're in the component method currently, that you have all your line items broken out, and you want to move to the pooling method where everything is in one bulk, one cash account and can be used for anything. It does require a membership vote to move the prior reserves into all pooling method. If you can't get that membership vote, you can keep the old reserves in the component method, and all new reserves moving forward, you move to the pooling method. The only downside to that is the accounting end of it. It becomes very complicated in the sense you as a board member and your bookkeeper need to make sure that whatever you're spending from, needs to be in the right method. So let's say roofing, what I would recommend is if you move to the pooling method for all new reserves, spend down all the old reserve components, use all that money first, then everything would be in the pooling method for future, and you wouldn't need that membership vote. The other thing that is, there's a lot of deficiencies in, and I actually meet with DPBR once a year. This year, they didn't do it, and last year they didn't. But what we discuss is, what are the deficiencies they're seeing being reported on the financial end? And they said the number one complaint is the pooling method schedule. We see it on our audit side. I would say probably less than 10% of associations are doing the pooling method correctly. You need to have a schedule of every asset, and it needs to go out to the longest life of the asset. So let's say your longest life is concrete restoration, and the estimated life on that is 50 years. The schedule has to go out 50 years. If your roof is your longest life and it goes 30 years, the schedule has to go 30 years. Where the discrepancy happens is, let's say painting. So the board comes in and puts the schedule together and says, painting is 7 years. So the schedule goes out 30 years. They put painting in at 7 years, and they never put another expense in. Well, painting should be done 7 years, 14 years, 21 years, and it has to be in the schedule when that is to be done based on the estimated life. It doesn't mean you have to do it in 7 years, but that's how the schedule is done. What we have done as a firm, we have come up with an Excel spreadsheet that does the actual calculation for you. So you plug in the numbers and it all calculates for you. If anybody would like a copy of that, we're more than happy to give it to you, because that is the number one problem, and DPBR gets the most complaints on the pooling schedule, and it is complicated. It's not just straightforward. If you guys send us an email, we're more than happy to give that to you, and you can look at that to make sure that if anybody turns you in, you have the correct schedule. Also, if you have your reserve studies done, they're not required by statutes anymore every 5 years, but we do recommend that if you are a board, to have it every 3 or 5 years. If you do updates, it's inexpensive. Do maybe a major one every 5 years. The reason I say that is costs changed all the time, especially with COVID now. We've been hearing from a lot of our contractors that cost of materials are skyrocketing because they can't get the materials, especially in Florida right now with, the surplus of building. We do a lot of work on the West Coast, and the West Coast is, the amount of developments that are going up over there, they said they can't even get the materials in to do the work. So that increases the cost. So that schedule you had 3 years ago, the estimated replacement cost could be drastically different. And you think you're fully funding, but you're actually not, based on all the new. So we do recommend to have it done every 3 to 5 years. It's just good business practice.
Yeah, one of the illustrations of that is they talk about the effects of some of these hurricanes, and it automatically raises the future prices of the repairs and or replacement because of the hurricane and the supplies that are available, as well as the manpower that's out there as well. So, and just one final note on the component versus the pooling. The component to illustrate would be as if you had you needed $500,000 to replace the roof in 5 years. That would be $100,000 a year, simple math. And as Nicole's saying, when you're in that pooling method there, the schedule gets kind of, elongated because you're going out to the longest year and you've got all these different components that you're all computing together as one number versus the component by component method that you have when you have roof and paving and painting and the like.
And you're required by statute 718 if you have statutory reserves. All 718 are statutory reserves. So I want to make that clear. It is required to have painting, paving, roofing, and anything over 10,000. When you put out your budget, you're required to have a schedule of the reserves fully funding. If you decide as a board, we're going to fully fund, you do not need a vote of the membership. You can fully fund reserves and never get a vote of the membership. The problem with that, if you're an older building and you've never funded them, the fully funding is probably so expensive that you would need to get a vote to partially fund. If you want to partially fund or waive reserves, it does require a membership vote under 718. 720, this has become kind of the Wild Wild West of HOA reserves. I call it that because it's so unknown. I always say, if you're not sure if you have statutory or non-statutory under 720, please contact your attorneys. That's who you need to talk to educate you on, are you non-statutory or statutory? Statutory reserves would be if the developer established them, and if you're a 40-year-old HOA, you might not know if the developer established them. And then non-statutory is they're basically voluntary board reserves. They're basically a savings account. They can be used for other things than their unintended purpose. Statutory reserves, they are only to be used for the statutory items that you have and can only be used for those line items. We have a lot of write-ups with that too, where boards will say, well, we're allowed to borrow from the reserves and we'll pay it back. I don't see anywhere in the statutes, and Scott can comment on this, where it says you're allowed to borrow from reserves without a membership vote. So a lot of audits, these 718s are getting written up because they're borrowing from the reserves. And in the audit, it says you potentially have a violation of 718. We don't say you definitely do because we're not attorneys. And then we always say, talk to your attorney to see if you do have a violation. But you want to make sure that you're not having that in your audit report, because any member that picks that up says, what is the board doing? They shouldn't be borrowing. If you need to do that, you would actually need to talk to your membership. They're very strict on that.
What are the trends now in terms of fully funding and partially funding? And can you also talk about now with COVID and these storms of lines of credit that the associations have gone out with?
That's a great question. So most of our new associations are fully funding. They're brand new. Most of the stuff is new. They're saying, let's do fully funding now, which is a great business decision because everything's new. So your cost of fully funding is very low. Your older communities, what you're noticing is they're getting all of the work done. They're not funding the reserves. They're saying, let's get everything up to where it should be. Then they start fully funding because everything is basically brand new, but they're special assessing for those projects. But in 2020, what we got a lot of information on was most of our associations were saying, there's a lot of work to be done. Let's do it now because interest rates were so low. To get those loans, they're saying, let's take out the loan. Let's get all the work done. Why interest rates are where they are. Then we'll pay it over a period of time. And then we can start funding the reserve. So when it comes due in 20 or 30 years, we'll have the money to do it versus special assessing. So you are noticing the trend is moving towards more of funding reserves versus the waiving. I think people are realizing that waiving causes a large special assessment down the road. So if they do it now, get the work done and then start funding, it's a much, and people buying in these communities, where, as you all know, everybody knows that Florida is being infiltrated with people from the Northeast. Everybody wants to be in Florida right now. So they're coming down and saying, let me find the buildings that are financially solvent, that are funding those reserves, so I'm not hit with these large special assessments from prior years when I didn't live here. So I think you're seeing a lot of that.
The mindset has definitely changed from, it's not going to be my problem in 10 years to, you know, I'm buying into this building now and I got to make sure that it's going to be here and in good shape.
One last comment before I turn it over to Scott, that we see a lot in our year-end financials, and I can't stress this enough to the board members. Please, anytime you are getting involved in contracts or anything legal, call your attorneys. I see all too much that they'll have somebody on the board that says, well, I know it, or I was an attorney in my prior life, or I was a prior CPA. I don't know what that means, but please, if there's too many mistakes that happen, it is so important. It is worth every penny to rely on your attorneys, because then you have relied on the professional and they give you the best advice, and you don't want to be stuck in a bad financial contract.
Well, Nicole, on behalf of all attorneys, we accept your shameless plug, so thank you very much.
They need to call you guys.
Well, I do want to underscore, you know, some very important points that Nicole and Bill just stated as it relates to reserves. And probably the biggest legal distinction between homeowners associations and condominium associations is the reserve issue. As Nicole stated so eloquently, we have a statutory obligation for condominium associations to collect for reserves unless properly waived at a membership meeting. And what's the vote that's necessary to waive the funding of reserves, either partially or fully? Generally speaking, you need a quorum of the membership present. So quorum is typically low as it relates to these types of votes. Oftentimes it's 30 or 33% of your membership. So if a quorum of the membership is present in person or by proxy, so submitting a limited proxy voting in favor of something constitutes your presence, and you have at least that 30 or 33%, whatever your association governing documents require. And 51% of those persons that are present in person or by proxy vote in favor of waiving fully funding the reserves, then you could do so. But that's as it relates to condominium associations. It's an important distinction with homeowner associations. It's a rare case that a homeowner association has mandatory reserves. That doesn't mean many HOAs don't have reserves. It's good practice, as Nicole was stating, to have reserves on the association side. But that really operates as just a kind of contingency fund. It's not dictated by the component method where you can only spend money for a particular a type of project based upon how it's stated accounting wise, which it may be stated accounting wise in your association accounting records to replace the clubhouse roof or refurbishment of pool, even if it's designated as such and you have that distinction. If it's non-mandatory reserves, it's a contingency fund, no matter what the label, the benefit from a homeowner association perspective is you could dip into those monies for any reason whatsoever, including an operating deficit. If there's a shortfall in a given year because assessments aren't coming in at the regular rate, or there are large projects that the association is taking on, capital improvement or otherwise, it's an extremely flexible, I think Nicole used savings account, that that reserve label, that reserve account, it can be used for those purposes. Again, totally different with condo associations, quite particular in terms of what you have to do. I agree wholeheartedly with Nicole and Bill. If we could get it to a pooling method, that gives you additional flexibility, but that does require a membership vote, because the default, if there's no selected accounting method with the membership vote, it defaults to the component method, where you put monies in different silos, as I call it, for the various projects that have a $10,000 or more repair cost. That generates a required category for collection of reserves. I'm going to backtrack just a tiny bit because I want to just make sure I covered all the areas where a 14-day notice is required. And I think I neglected to mention that when the association is seeking to specially assess the membership, that particular meeting has a special notice requirement of 14 days. And that notice has to be drafted in a very particular way where the exact amount of the gross amount of the special assessment has to be referenced in the notice, further broken down to how that special assessment will be chargeable to each unit owner, as well as how it is payable and what the money is to be used for, the nature of the project, and with some level of detail. So that's an important add-on to what I was saying before in terms of the 14-day notice requirements. And all of these things that we're discussing, the notices, the limited proxies, meeting minutes, budgets, as Nicole and Bill were talking about, these are all business records of the association. There's a long list of categories of items which constitute business records of the association. These business records have two important features to them. They have to be retained for a period of 7 years by statute. So that's almost always done by your property management company, is they'll retain these records for that purpose. And they're retained for this period oftentimes because members do have the right to request an inspection of these business records as they so choose. This is a process that oftentimes trips up associations where a request may come in and it's not attended to timely. And if it's not attended to timely, and when I say timely, I mean 10 business days. If the documents are not made available for inspection within that time frame, there's statutory penalties, both on the condominium association and homeowners association side, of $50 a day up to a maximum of $500. Now, $500 doesn't sound like the end of the world. However, in the event the member is quite irritated that they didn't receive the business records in whole or in part, they can hire an attorney and a lawsuit could be filed over the failure to make these records available. And the $500 extends then to also the member's attorney's fees as incurred as relates to that litigation ensuing over the failure to make documents available for inspection. Important procedural component to these requests are that emails coming in from a member that's demanding to see copies of last year's budget, copies of vendor contracts, that actually does not constitute a proper request to inspect the business records. By statute, the request has to come in either by mail or by drop-off to the registered agent or the principal place of business of the association, oftentimes the property management company. And the request must ask for an inspection of the business records. What does an inspection means? It means taking the documents if they're properly identified. And it doesn't mean give me all your financial records for the past 7 years. That's not a proper designation. There has to be an articulation of exact categories of records with some level of specificity. And if that is done, then the documents are to be put in a room for inspection purposes. Thereafter, copies may be made if there's a request made by the member during the inspection. Up to 25 pages can be copied at the association's expense at a cost of 20 cents per page. However, it does not mean that if an email comes in from a member, please email me copies of the following items. It's not a proper business records request and technically need not be responded to. But I would still err on the side of getting with counsel to make sure a proper response is sent out so you don't run afoul of the statutory requirements.
Scott, has there been any provision changes with respect to the fact that we're in an electronic age with PDF files and COVID-19?
Well, yes, in the sense that there have been arbitration decisions which have provided that if the association does send out the documents electronically by email with an attachment, that would constitute compliance. So the association is not obligated to send it out in that manner or method, but if they do so, it would be satisfactory under the statute.
And what about the collection fee? There's 20 cents a page for copying. Is there any fees that are allowed to the management company for producing a PDF or
That's a good question, and it depends upon if rules and regulations as it relates to the inspection of records requests have been promulgated by the board of directors. It's a good idea, and I've done this many times for many associations. I have a set of policies and procedures as it relates to these business records requests, which incorporates an administrative fee payable to the property management company or the association for the time, cost, and expense of overseeing that process. But that does have to be adopted at a properly convened board of directors meeting with that resolution being part of the business records. Without that type of provision, either in your declaration, it's rare to see it in your declaration, but possible, or through a resolution that's circulated to the community, then technically there's no right to charge that type of administrative fee or cost.
Okay, thank you.
Since we're talking about rules and regulations, that'll be my next topic real quick. Rules and regulations are a very useful tool, but sometimes abused, frankly, by boards of directors. The rules and regulations are there to supplement and kind of fill in the gaps, per se, as far as the various provisions of your declaration. Whether you're a condominium association or a homeowners association, your primary document is your declaration. Sometimes I heard it called neighborhood covenants or some other similar title. But that main document, typically at least 20, 30, 40 pages in length, that constitutes your constitution of your community. That is the document by which the association and all the members are to live by. But sometimes they're not sufficiently detailed. And the rules and regulations are there to set forth additional provisions, rules, requirements, and they should be used for relatively minor procedural things. For instance, establishing the rules for the usage of the pool, or parking rules, or perhaps establishing criteria to approve or disapprove of a tenant. But a board should not seek to revise what already exists in your declaration through rules and regulations. Now, it's the easier method to adopt rules and regulations. That's perhaps why you may see a board go in that direction, because rules and regulations only need to be adopted by the board of directors, as opposed to an amendment to your declaration, changing something that already exists in your declaration. That requires a membership vote. It's almost always a 2/3 vote, both in condominiums and homeowner associations. You need 2/3 of all eligible voters to vote in favor of an amendment for an amendment to pass. That's difficult to achieve, for a variety of reasons. So, boards, as they are able, would like to use the rules and regulations process, which I'm all in favor of. However, if the rule itself is covering a topic that's already been addressed in the declaration, then the rule and regulation likely will be deemed invalid. There's a whole body of case law how a rule and regulation could not be inconsistent with an express or a term or an inferred right already set forth in your declaration. But in the absence of such a express or inferred right in your declaration, go for it. We could create rules and regulations, and they can be useful for that purpose. The notice requirement for a board of directors meeting involving the adoptions of rules and regulations is either 48 hours or 14 days, depending upon the nature of the rule and regulation. If the rule and regulation involves, and here's the language coming straight from the statute, involves and affects parcel usage, then the 14-day requirement is necessary, where the proposed rule has to be sent out at least 14 days in advance, and the board of directors convenes its meeting 14 days after the notice is mailed. What does parcel usage mean? Well, if we're establishing the way in which architectural improvements are to be conducted and procedures related to that, that affects parcel usage. If we're talking about different types of occupancy within your unit, how many family members can stay with you for how long a period of time, that's parcel usage. That requires that 14-day time period. But we were just talking about, saying, the inspection of business records. That does not affect parcel usage. So the rules and regulations can be adopted on a 48-hour notice type schedule. So those details are important, because you will have a member, if you don't already have a member, that will challenge the validity of your rule and regulation. And a crafty attorney will look at the underlying procedure to see how that rule was adopted. Was proper notice given? Was a board of directors meeting convened? Is it properly reflected in meeting minutes? Dotting these I's and crossing these T's at times sounds or seems like a chore. It will save you a headache down the road and potential legal action. Okay.
Hey, Scott, while we're talking about rules and regulations, I've got a couple questions here about violations. Is that something that you'll be talking about?
Yes, but we could fire away and we could jump into violations, because that's typically a popular topic. That is one of my areas, but we could dive into it right now. Okay.
Well, one of the questions is the current board statute allowing fining by the board in confirmation of a violation committee superior to that amendment. Ultimately, this board member put together a amendment, and he's wondering if the violations committee seems like supersedes that amendment.
Okay, well, let's start with this principle. Fining a member is only permissible if there exists a properly constituted fine committee. So without, and sometimes it's difficult to get folks to volunteer to be in a fine committee. It's probably not the most popular committee to be on, to find your neighbors and say you've done something wrong. So some associations struggle in finding those types of volunteers. But if you're able to convene and appoint members to a fine committee, which should be at least 3 in number, and 3 is kind of the right number, no more than 3. I would go with 3. That seems to work the best from a practical standpoint. And those fine committee folks cannot be members of the board of directors, and nor they can be related to any of the members of the board of directors, but they have to be an owner. They can't be some person off the street. And you have a fine committee, then you have the right to fine. And the right to fine is subject to 2 things: what the statute allows and what your governing documents provide for. Maybe this goes to the particular question, Jonathan. Statutorily, the maximum fines are $100 per violation for each day of that violation, up to a cap of $1,000 for each category of violation. So it's $1,000 for any one single violation, essentially, but you can have multiple violations involving a particular property, and you can have multiple fines that amount to $1,000 a piece, possibly. However, big however, what if your governing documents, as some do, say a violation will not exceed $50 per day, but the statute allows 100? You're stuck with $50 a day. That's the maximum. You're bound by the express term of your declaration. Perhaps another good reason to look to amend your governing documents. And when you amend your governing documents, you try and throw in a whole bunch of things that you'd like to see changed, and that could be one of the line items. I think I answered the question. What was the second part of that, Jonathan?
The second part was regarding a amendment that he had drafted, and I directed him to contact you directly because that seems like it might be based off the amendment that was drafted.
Okay. Let me clarify the fine process, because this is oftentimes not done correctly, and it's counterintuitive, so it's easy to confuse it. Plus, the statute about 6 years ago used to say something completely different. The process is as follows. If there is a violation on property and it comes to the attention of the association, which could come from any source, from a neighbor living next door, the rover driving through the community that identified a particular problem at a home, from the property manager that's doing inspections, from a board member that became aware of something, and it's clear cut that there's a violation. That issue is put before first the board of directors at a duly convened board of directors meeting, where the board will then decide to impose a fine. Now, it's good practice, and this is oftentimes done, where the property manager will send out a relatively polite letter giving someone a warning. Please take care of this issue. Your roof is dirty, and please take care of that within 30 days. Oftentimes you see property managers in the association will even send out a second warning letter. That's not a bad idea either. If those warning letters are ignored, then it should be put, as I was saying, before the board of directors for the purpose of imposing a fine, reflected in meeting minutes. Very important, because that could be subject to review later on. After the board of directors has decided to impose a fine at a duly convened board of directors meeting, not behind the scenes by email, on a board of directors meeting, then the fine committee process starts. And the process involves establishing a fine committee hearing at least 14 days out, with a notice going out to the homeowner, advising the homeowner the nature of the violation, the amount of the fine, the date of the fine committee hearing, and the time and the place and location, for the owner to be able to show up and state his or her case. And the fine committee will sit there essentially as judge and jury, and will listen to what the owner has to say. The association will have their representative present, whether it's another board member or typically it's a property manager, to state what the violation was and how long it's been going on for. Then what does the fine committee do? The fine committee does one of two things, and only one of two things. Either upholds the fine, says, yes, we agree with the board of directors' decision, and the fine is upheld, or the fine is rejected if the fine committee decides that the violation didn't really exist, or they could come up with any reason whatsoever as to why to reject the fine. What the fine committee is not supposed to do is come up with a middle ground approach and say, we're only going to fine you. I know the board fined you $100 a day, but we're going to reduce it to $50 a day. Or how about we'll do this? The $100 per day fine, we're going to hold that in abeyance. We're going to give you another 60 days to fix the situation. Although that sounds reasonable, that is not statutorily compliant. The fine committee cannot make a decision in that manner. So be mindful of what the fine committee's role is and limited role in that respect. I oftentimes are asked whether or not the fine committee members should be going around the community and finding violations. I don't see it as a good idea, because then you essentially have the fine committee members being the fact finder, being the investigator, and then sitting in almost in an appellate capacity to decide whether or not the violation took place. I know it's difficult to find volunteers, but the existence of a violation should come from someone other than a fine committee member. They should be disassociated with that aspect, the investigation, the underlying violation.
I agree. In that case, then you're the police, the judge, and the jury. So
Right.
no point in that. I do have another question as it
Yeah.
pertains to the board of directors. Are they immune to violations? Can they be included in that? As well as if directors are asked to sign like an ethics code or maybe something that's outside of the rules and regulations or bylaws, can they be fined for those, for that ethics code that they have agreed to?
Fine, members of the board of directors are subject to violations and fines just the same as a member may. Now, it all flows from the existence of rules and regulations and the dictates of those rules and the declaration. So if there's a violation of the declaration or a violation of a rule and regulation by a board member, that board member is subject to a violation and a fine just like any other member in the community. Now, something such as like ethics rules that were adopted perhaps by the board, it depends if those are advisory in nature. It depends if those are their suggestions or if they're actual rules and there's a concrete violation. But if a board member is acting in a manner that is not in the best interest of the association, and particularly, and I've seen this quite a bit with members of board of directors that take it upon themselves, say, to do things that are way out of bounds, that are not consistent with the role of board of directors. I've written letters to this effect where I am stating that board member is interfering, and here's the phraseology that I use, interfering with the governance of the community by making decisions without the authority to do so, by acting in a dictator type manner, that could constitute a nuisance, which is one of these catch-all provisions that you see in most governing documents that could give rise to a violation and potentially a fine. So perhaps one of the violations of one of these ethics type provisions might fall into that category of interfering with the governance of the community, constituting a nuisance, giving rise to a fine or violation.
I'd like to interject something.
Sure.
I know when it's hard to find volunteers, you could maybe do this. I actually helped a couple of boards with this to get maybe 3 volunteers for 6 months. And then while those 3 are in place, start recruiting 3 other people and then kind of do a rotation. It also gets a buy-in to the community. Everybody starts feeling like there's not just 3 or 4 people, being on watch. And it helps everybody, hey, well, I'll do it for a while if you do it for a while. So instead of making it a concrete position like the board, maybe a little bit of fluctuation on who is going to be on the finding committee. And maybe the board members should just ask their neighbors, hey, would you do it just for, a few months? And then rotate it. Sometimes sharing it takes a little bit of the edge off of the implication of what, the committee is offending the neighbors, and the attitude of that. So
that's a good suggestion. And it's important that you rotate folks through that finding committee. That they'll have more of a vested interest in the community for sure. And aside from fines, and I get asked this question quite a bit, Scott, what are our options here? We have this person that's just doing this and they won't stop, and they're not paying the fines, they're ignoring them. There are other options here, and it depends if it's a condominium association or a homeowner association. I'll talk about HOAs first. There's the pre-suit statutory mediation process. If someone is acting in contravention of language in your rules and regulations or your declaration, you can actually file a lawsuit over it. There's a administrative exhaustion requirement where you have to ask the member to participate in mediation first. If that member refuses to participate in mediation, this pre-suit statutory mediation process, then you can file suit. And the suit takes the form of typically something called injunctive relief, which is a fancy way of saying, asking the judge to order the person to stop doing it. And that is a useful process. It can go through the court system fairly rapidly if there's something emergent where you can get before a judge on a motion for temporary injunction, perhaps within a few weeks, sometimes. So that can be used in extreme situations. For condominiums, you don't have that same pre-suit statutory mediation process. You have to first go to the Division of Condominium to obtain an order of arbitration compelling someone to stop doing something. And from there, it could actually go to circuit court in Palm Beach County to obtain a further order of the court. So it could be a long and expensive process in either scenario. If association's truly in the right, the association would potentially be awarded all their attorney's fees and costs incurred in that process. But there's oftentimes an upfront investment of monies to prosecute cases such as that.
Hey, Scott, quick question for you. Has there been any issues with COVID-19 in litigation that's come up with maybe the association not taking steps or people not social distancing, or have you seen any, action in that area, so to speak?
Well, there was a recent lawsuit filed about a month and a half ago in a condominium association, where a condominium association was alleged to have acted a bit overzealously in terms of the condo association learning of the existence of one of their owners' residents became infected with the virus, unfortunately, and they put some very serious restrictions on this person that guests could not visit the individual. The individual had limited ability for ingress and egress out of the condo association building. It resulted in a very serious lawsuit filed in circuit court. It's working its way through the court system. But in a scenario such as that, these are obviously difficult, tricky issues because particularly in the condo association context where you have people living on top of each other and next door to each other, the existence of the virus in the building could easily impact others. And the board feels obligated to a large degree to protect the residents. And that is part of their charge, in fact, the health, welfare, and safety of the residents. So arguably, they should do everything necessary to keep this person locked down. However, that rubs up against the owner's right, it's for regular ingress and egress out of the community, not to have his or her name, that's another part of the lawsuit, his name disseminated throughout the community as being infected with COVID-19, which is a violation of privacy laws, which is a big aspect of this lawsuit. So, as in the condo association world, you really have to be, you have to carefully construct your rules as it relates to these types of issues, not to be overboard, not to be overly restrictive, but have some reasonable restrictions, say in terms of contractors accessing the property, because you don't want this endless flow of guests and contractors coming in and out. A check-in procedure is reasonable. Temperature checks are reasonable and sustainable, but prevention of the individual from leaving the condominium building or their unit probably is a step too far.
Okay, thank you.
And as it relates to COVID-19, there is a statute that is being proposed that the legislature in Tallahassee is considering adopting come July 1st, and this will benefit associations. If the association has made a good faith effort to substantially comply with controlling government issued health standards or guidance or CDC protocols, that associations and other similar entities would be immune from liability. So it's subject to these good faith compliance. What is good faith compliance? I mean, that depends on the particular facts and circumstances within your building. There's also a tight statute of limitations that is considered, that is being considered 1 year for that individual who feels aggrieved to file a lawsuit. So this is an effort on the part of the legislature to limit liability in these situations. We'll see if it gets adopted in Tallahassee. As it relates to fines, I wanted to also mention, so I could flow into another category where Nicole and Bill will chime in. Fines are lienable. If an individual is fined a certain amount of money, that could be the subject of a lien for homeowner associations, not for condominium associations. So that's another large distinction statutorily, where if you're in a homeowner association and a fine has not been paid, it would be the subject of a collection letter first, then potentially a lien. You can foreclose on that lien as long as that lien involves a fine of at least $1,000. So let's say you have the owner that is not delinquent in any respects, but has not paid fines amounting to $500. A lien is filed against the property. You can't take step 3, which is file foreclosure on that lien, unless that lien and that fine is at least $1,000. For condominium associations, it's completely different. You cannot file a lien for fines alone. So be aware of that distinction in terms of delinquencies for unpaid fines. Perhaps we'll jump to Nicole and Bill, category 11, which is the application of monies received on a delinquent owner account. This is a tricky category because what you may see with a unit owner account is an unpaid amount where someone just missed paying 1 month for one reason or the other, and late fees end up resulting and go in that account. If the unit owner doesn't quickly catch up and pay that unpaid month, the next month's payment, and I'm perhaps stepping on Nicole and Bill's toes, will end up being applied first to those late fees and other potential charges, and the assessments for the following month will remain partially unpaid. So maybe Nicole and Bill, you guys could talk about that topic.
I'll talk about that from the tax perspective, but you're absolutely right, Scott, is it needs to be applied to those interest and those late fees first and then to the maintenance. But one of the things we see is that if there's delinquency and the board will come to us and say, well, you know, do we write it off? Should we take it off the books? And then if they pay. So from our perspective, from an accounting perspective, we tell them do not directly write anything off of the unit owners until the attorney tells you that you're not going to collect it, or there is a potential you will collect some of it. Either they're going into foreclosure and the bank's taking control of it. But from our perspective, we tell them to leave everything on the books until you actually have an opinion from the attorney that it will not be collected. If it will not be collected, then it gets directly written off, and then it goes against the allowance for bad debt and it reduces that. But we always rely on the attorneys first to say, do we think we're going to have a potential to collect it or not? And then from a accounting GAAP standpoint, we decide if it's written off or not. From a tax standpoint,
yeah, from a tax standpoint, it's a little bit different for the associations than it is in regular business, because from a tax side, typically businesses will put up an allowance for the amount of the receivable that they have that they don't think that they're going to be able to get. And so that becomes an expense then on the books, and that's carried on until the resolution of that particular individual, whether it be in court or they go into potentially Chapter 7 or Chapter 11, whatever it might be. But typically, we take guidance from the attorneys, and it's been their feeling and their belief that we should leave that receivable on the books so that when they do go to court, anyone that is there can see that that liability still exists and it's an unpaid liability. So we carry it on the books, and we still follow the books in terms of taking a tax deduction for it. If it ultimately becomes uncollectible and the units then goes through foreclosure, then that receivable then goes toward basis in the property that they're selling, the unit that they ultimately sell.
and if they recover those dues, it's not a taxable event, correct?
Yeah, that's correct. Because they're recovering assessments that were due to them individually that wasn't subject to tax.
Right.
And you know, I'm going to take a step back, and we just talked about the micro aspect of having good accounting for delinquent owner accounts. You know, the macro aspect is, well, why is it important to have accurate, you know, account statements? It seems self-evident, But here's really an underlying issue that is important for all to understand. The Federal Fair Debt and the Florida Fair Debt Collection Practices Act is being an often used statute to sue associations for improper accounting methods. When a letter is sent out to a unit owner that contains an inaccuracy as it relates to their account, that constitutes a violation of the Federal and Florida Fair Debt Collection Practices Act, which oftentimes results in the filing of a federal lawsuit, and whereby there are statutory penalties for that, which are not enormous. However, like I was explaining in the inspection of business records type litigation, there's also an award of attorney's fees that gets attached to these types of claims and lawsuits. And again, the crafty attorneys out there who make a business of suing associations for minor accounting errors that are found in either a ledger or a claim of lien or a demand letter give rise to liability under these statutes and could cause real problems for the association. So it's important we have real crisp, clear, accurate accounting methods for that reason alone.
And we also tell them too that to make sure they have a policy of, after how many days are they sending out a letter? How quickly are they turning it over to the attorneys, and make sure they're staying consistent with every single owner. We've had associations where one person they're letting go longer, the other one they're turning to the attorney. And we know there's an issue with that because now they're not being consistent with every owner. So they should put in a policy for collecting people that are delinquent and making sure they're being consistent with every owner.
Right, and that goes for the assessment of late fees and interest as well.
Absolutely.
That, you can't just discretion say yes to one and no to the other.
Selective enforcement, I guess they call that, Scott.
Yeah, and it also comes down to what your governing documents say. So the ability and the authorization to charge a late fee or default interest derives from the express language in your declaration, or perhaps lack thereof. You can't just slap a late fee on an account if you don't have that language contained in your declaration. Oftentimes it does appear and does exist, but not always, particularly for older communities that have an older set of governing documents that might not be as current. So when sending out these demand letters and attaching to it a default interest rate of 18%, we have to make sure that your declaration gives the association the right to charge 18%, or if it says something like the highest rate permitted by law, that would work as well. But I've seen lots of sets of governing documents that say 10% or 5% or 12%. So consistency and accuracy and acting in conformance with the governing documents of your community are key. Another kind of macro comment here as it relates to the collection process. I'd like to kind of describe the collection process as having three distinct parts. The three distinct parts are, first, the demand letter. When an account is delinquent, a demand letter goes out typically by the attorney, although maybe it's 1 and 1A to be exact. One could be the property manager sends out a reminder letter that there's a delinquency, and that's perfectly permissible and perhaps a good idea. If that reminder letter is not addressed and payment is not made, then it goes to the attorney to send out a demand letter. There's a formal letter that needs to go out with particular language. The Fair Debt Collection Practices Act type disclosures have to be included in that demand letter. If not included, constitute a violation. That's why it's best for attorneys to send out these demand letters. And this is where, again, we diverge from homeowner associations and condominium associations. With HOAs under Chapter 720, if the demand letter does not result in the payment of the unpaid sum, then 45 days after that, a lien can be filed on that property for the unpaid sum. With condominium associations, it's 30 days. Not a big difference, but important to note. Thereafter, let's say a lien is filed and a copy of that lien is sent out to the owner, and the owner still ignores the claim of lien, and the lien has been recorded against the unit. Then with HOAs again, 45 days after that lien has been filed and recorded, the associations can file a lien foreclosure case. Just like a bank can file a mortgage foreclosure case, associations can do the same based upon the filing of the lien. With condominium associations, again, that time period is 30 days. I find the lien foreclosure actions, although sometimes boards are reluctant to take that step because there is an increased cost component certainly to filing a lawsuit. When you have a recalcitrant owner that is ignoring in the demand letter, ignoring the claim of lien, when they get served with a lawsuit, their tune tends to change, and oftentimes we get pretty darn good results just by the filing and the service of the lawsuit, which would include and always includes not just the unpaid amount, but all attorney's fees incurred. So the amounts demanded of the owner, if the owner says, okay, I've got your lawsuit, what do I owe? That amount is inclusive of all these sums, the outstanding assessments, late fees, default interest, and attorney's fees related to the filing of that case. Aggressive collection procedures works, in my opinion, and it should be utilized. Now, in times of COVID-19, that doesn't mean there can't be some semblance of empathy and working things out. And I encourage my associations when an owner is having some financial difficulties, if they want to engage in a payment plan of some sort, that the association should certainly consider it and entertain it as long as it's reasonable in nature. Nicole and Bill, is there anything from an accounting or tax standpoint that the association should know about when considering a payment plan from an accounting or tax perspective? Is there any difference from accounting standpoint? Will that impact at all any tax related issues?
It's a great question. From the financial side, it's not an issue.
No,
We don't
from the
have-
tax.
We're fine with that.
Okay, good.
If it was a situation where it was outside of a maintenance assessment, it could be a taxable event to them.
Right.
But if it's strictly a quarterly maintenance that they're in arrears on and they're paying it back over a point of time, no.
Very good. All the more reason for associations, to deal with folks that are struggling, particularly in today's day and age, to come together and perhaps have an agreeable payment plan, as long as it's not too lengthy in nature. And by and large, I suggest to my associations, nothing longer than 6 months, certainly. But it all depends upon the amount that's owed. This particular owner's track record. Is this the 7th time in the past 5 years that they've been delinquent, or it's just a one-time event where someone's lost a job or impacted by an illness? I could consider that.
Scott, is there any current moratorium on foreclosures similar to the rent on people not paying their rent?
There is not. There is not. So there's the new COVID-19 relief bill that's working its way potentially through Congress just pertains to mortgage foreclosures. And so it would have no impact whatsoever on homeowner associations or condominium associations.
Hey, Scott, I've got a question from Dominic. He said that there is a resident who insists, or I guess is always late in paying their maintenance and reserve quarterly payments, and does so deliberately. And after sending multiple emails, still won't make the payment up until they escalate it to that first step in what you're kind of just describing. I guess one quick thing, Dominic, at Vinteum, we've partnered with a couple payment processors who will automatically charge that ACH or credit card on a monthly basis. That might be able to help you out. But from a legal standpoint, Scott, is there anything that can be done just to eliminate that workload from the administrator in order to get this resident to pay?
Well, each and every time they miss a payment, and if they're ignoring first of all, you can charge an administrative fee potentially if, say, the property manager is sending out that initial reminder letter or late letter, sometimes I call it. You could tack on an administrative fee, provided your governing documents have enough, I call it language latitude, to allow for such a charge. In a situation like that, if you're a unit owner and you're consistently getting charged either an administrative fee or the attorney's fees for a demand letter, I would think at some point that would get tiresome and that you would just pay it on time because it's costing you each and every time you go delinquent. Speaking of delinquencies, a a problem that maybe doesn't exist as much today as in, say, a decade ago, are mortgage foreclosures. We all remember the real estate crisis, say from 2006 to arguably 2013 or so, where a good number of properties were the subject of a mortgage foreclosure. And if an individual is in the process of potentially losing their home as a result of mortgage foreclosure, there's a pretty decent chance they may stop paying at some point the association assessments, and delinquencies start to rise pretty heavily in those situations. How does the association recoup these funds? Well, when a mortgage foreclosure concludes, at the tail end of a mortgage foreclosure, there's something called a certificate of title that is issued. 95% of the time, it is the bank that becomes the owner of that property. And we're going to talk about the other 5% in a second. When that bank becomes the owner of the property in a mortgage foreclosure context, statutorily, the bank is obligated, unfortunately, not to pay the entire back set of assessments that are outstanding. That would be good, but not the case. The legislature created under Chapter 720, 3085 to be exact, a procedure where that bank would then owe something called the safe harbor payment, which is equal to 1 year's worth of assessments that are unpaid, or 1% of the unpaid of the principal, the original principal balance of the mortgage. Here's the key language: whichever is less, unfortunately. So let's use a hypothetical. Let's say there's a $300,000 mortgage that is being foreclosed by Wells Fargo, and Wells Fargo ends up becoming the owner of the property as a result of that foreclosure process. And the annual assessments for this property are $2,000. What you'll have is a comparison. The $2,000, the annual assessments are $3,000, which is 1% of that original $300,000 mortgage. So the safe harbor sum in that hypothetical is the bank would owe the association $2,000 plus all the assessments that come due after the issuance of the certificate of title. So once that CT, as I call it, certificate of title is issued in the name of the bank is the owner, and the bank becomes responsible to pay the assessments just like every other member going forward. Now, there are a couple of unique procedures to really recoup some sizable sums if there are surplus proceeds. Now, years back, we never saw surplus proceeds because properties were so underwater. You just rarely saw at a mortgage foreclosure sale a bidder bidding a sum in excess of what is owed on that mortgage. Today, you're seeing more of that. And what happens as a result are surplus mortgage foreclosure sale proceeds deposited with the clerk of court. And as a lien holder, the association, whether condo association or homeowner association, would have the right to be pretty close to first in line to recoup the surplus proceeds for the purpose of applying it towards any back balances that are owed on the account. And that is true also with respect to tax deed sales. If someone's not paying the mortgage and not paying their association assessments, decent chance of not paying their property taxes. In a property tax situation, after 2 years of a tax lien being issued, a property could be the subject of a tax deed sale, where there could be tax deed sales surplus proceeds deposited with the clerk of court. Association as a lien holder will be notified of the existence of those surplus proceeds, and we would make a claim for those surplus proceeds, which could be used to recoup a goodly portion of the unpaid amount due on that account from that delinquent owner. We've done this dozens of times, and it's a terrific way to infuse a good amount of money and recoup unpaid sums. Maybe I could throw this back to Bill and Nicole in that situation of the association recovering some mortgage sales surplus proceeds or tax deed sale surplus proceeds, or any accounting or tax issues to know
of. No, there isn't, but the association or Condo can go out and look on the website. Palm Beach County Property Appraisers has a website where you can go out and either put in the block and lot number or the person's name, and it'll come up and show you the history of payment there and where it actually stands. So even going into the situation where you're going to bring suit against them, you'll know what the status is before you even start.
Okay, great.
And it gives it also gives the association the opportunity, if it's in foreclosure, to go ahead and pay that, those property taxes to keep the property in play as well.
That's right, particularly in a situation where an association has, say, already foreclosed on their lien and they're the owner and they're renting out the property and deriving some nice income. And there's no mortgage foreclosure pending and looming where the association will lose title to the bank. And the association is enjoying reaping the benefits of the rental income, but the property taxes haven't been paid for some time. There has to be a business decision made by the association to pay those delinquent property taxes because it may be worthwhile to do so to continue to receive these rental payments as the owner. If not, and the taxes stand as delinquent and the property goes to a tax deed sale, then the property could be lost and that tenant will no longer be your tenant because there'll be a new owner for that particular unit.
Correct.
So let's talk about, I said the 95% of the time, the mortgagee, the bank, becomes the record owner of the property. What happens in that other 5% of the scenarios? Sometimes, and more often today than 10, 15 years ago, you're having third parties, individuals, companies, LLCs, buying property at a mortgage foreclosure sale, thinking it's a good investment opportunity. In that situation, statutorily, the association has the benefit of being able to say to that third party owner, congratulations, you're now the record owner of this property. You now owe all the back assessments because the statute allows for that up to 5 years worth because that's the statute of limitations. Unless, and here, again, there's an exception to every rule, unless your governing documents provide otherwise. There's a case called Pudlit, P-U-D-L-I-T, you can look it up, that talks about the association being restricted in terms of recouping all these back assessments statutorily if there's language in your association's governing documents to say something like, upon transfer of title as a result of a foreclosure or deed in lieu of foreclosure, the record owner will be absolved of any liability for past due assessments. If your documents unfortunately say something to that effect, then you can't go after that third-party purchaser for the past due assessments. But a good majority of cases don't, your documents will not say that. So you'll have a fairly decent chance of recouping 5 years worth of back assessments from that third-party purchaser, who oftentimes are unwittingly learn that they've just assumed this large liability. So keep that in the back of your mind when there's a mortgage foreclosure sale to a third party, a new record owner. There's a potential ability to recoup a goodly amount of sums from that third party investor. Speaking of documents, and I know we're running out of time, but I'll just touch on this real quickly. And this is another example, maybe the theme of my presentation of the divergence between condominium associations and homeowner associations pertains to the Marketable Record Title Act, which is a obscure law that says if your governing documents, and I'm really simplifying it because we don't have time to go through all the nuances, if your governing documents are 30 years or older, and there are a lot of exceptions to this, but I'll just generalize it. If your governing documents are 30 years or older, they would be deemed, this is for homeowners associations only, your governing documents would be deemed expired, invalid, unenforceable. Kind of disastrous for your association, frankly, if that were to occur. How do you, and what does that mean from a practical standpoint? Is that you cannot collect assessments, you cannot enforce your restrictions, you cannot impose fines, you can't say someone's in violation. It's really traumatic to your community. How do you avoid that from happening? Because many documents are decades old. Simply by filing something called a notice of preservation before this 30-year mark hits, a 2-page document typically adopted by the board of directors, recorded in the public records, then you avoid this mishap of your documents inadvertently expiring. Again, this has no application to condominium association world based upon the way deeds for condominium units are typically reference your governing documents and the nuances of the Marketable Record Title Act. So if you're in a community that has been around for some time, take a look at the date of your declaration. If you're in a homeowner association, to see if you're creeping towards that 30-year mark. What if you've already hit that 30-year mark and you have not, and your association has never dealt with this and filed the notice of preservation? There's a procedure for springing your documents back to life called revitalization, which is very involved and very expensive, where you have to get at least 51% of the members to approve of the revitalization of your governing documents. Way easier, way simpler, way cheaper to just attack it before you hit that 30-year mark through a simple notice of preservation that is simply a board action with the assistance of your attorney. I know I didn't hit a number of topics about rental restrictions and adoption amendments, procedures. There's just so much to cover. As you know, financial end, Bill and Nicole did an incredible job hitting some important points. I think you guys will have my email if you want to fire a question my way after today's seminar. I'm happy to chat with you by email or by phone. But I think that concludes our presentation, and I very much enjoyed it.
Great job, Scott.
Thank
It's
you,
very
Scott.
informative.
Great job, everybody. Yes. And let me just mention one more thing is that I will be sending out a sponsor sheet. It's something new that I'm doing, which will have everybody's contact information on. So it'll be easy for everyone who registered to have information on our sponsors today.
Thanks
Jonathan?
so much, Peggy. That's a good idea.
Thank you, everybody, for attending. All of the content was fantastic. Thank you very much for helping us out. Nicole, Bill, Scott, it was fantastic. So thanks for that.
Thanks, Jonathan and Beth. Thank you guys both.
Thank
Everybody have a
you.
wonderful day.
Thanks, guys.
Thank you.
Take care now.
Bye, everybody.
Bye, everybody.